On January 18, 2017, the Utah Supreme Court issued its decision in the case of Snyder v. Hertzske. Here is the link to the court's full decision, and we've also included the link in the video description section of this video report. Linda Snyder and Tyler Hertzske each claimed sole entitlement to the death benefits of a life insurance policy held by Edward Hertzske, who had died. Prior to the divorce, Edward Hertzske obtained a $500,000 life insurance policy naming Ms. Snyder as the primary beneficiary and Tyler Hertzske as the secondary beneficiary. The terms of the policy provided a method for naming new beneficiaries during Edward Hertzske's lifetime, but were silent as to whether the designation of a spouse as a beneficiary would survive a divorce. Ms. Snyder and Edward Hertzske were married in March 2005. In May 2013, Edward Hertzske executed his will disinheriting Ms. Snyder, quote, to the fullest extent permitted by law, close quote. In January 2014, Edward Hertzske filed for divorce. On May 6, 2014, the court issued a divorce decree that was silent as to the policy. Edward Hertzske died less than a month after the divorce decree was entered. Both the ex-wife, Ms. Snyder, and Tyler Hertzske declared an interest in the policy funds. The district court ruled in favor of Tyler Hertzske. Ms. Snyder appealed the decision, and here is how the Utah Supreme Court analyzed the case. Under Utah Code Section 75-2-804 sub 2, a beneficiary designation in a life insurance policy is revoked upon divorce, but the presumption can be rebutted by express terms in the life insurance policy, a court order, including a decree of divorce, or a contract relating to the division of the marital estate made between the divorced individuals. Utah Code Section 30-3-5 sub 1e, however, provides that this revocation can be rebutted under Utah Code Section 30-3 sub 5-1e if the decree of divorce includes an acknowledgement by the court that the owner of the policy, 1, has reviewed and updated where appropriate the list of beneficiaries, 2, has affirmed that those listed as beneficiaries are in fact the intended beneficiaries after the divorce becomes final, and 3, understands that if no changes are made to the policy or contract, the beneficiaries currently listed will receive any funds paid by the insurance company under the terms of the policy or contract. But during the divorce proceedings, neither Edward Hertzske nor Ms. Snyder mentioned the policy in the petition or subsequent divorce proceedings, nor did they identify or reference Utah Code Section 30-3-5 sub 1e. Where the court was not aware of any existing life insurance policy and the statutory language from Section 30-3-5-1e was not included in the decree of divorce, the presumption that the former spouse is revoked as a beneficiary remains. Therefore, Section 75-2-804 applies here, and Ms. Snyder is presumptively revoked as a beneficiary on the policy absent express terms in the policy indicating otherwise. Furthermore, the generic language found in almost every life insurance policy regarding the standard method to change a beneficiary does not constitute, quote, express terms, close quote, enabling the beneficiary designation to survive revocation under Section 75-2-804 sub 2. It is standard practice for life insurance companies to, quote, prescribe formalities to be complied with for the change of beneficiaries, close quote. This is not for the benefit of the policyholder or the beneficiaries, but for the protection of the insurer. Were Utah to adopt the notion that these formalities constitute express terms in a governing instrument, Section 30-3-5-1e would become superfluous. There would be no need for Section 30-3-5-1e's specific method to rebut the presumption for life insurance policies in divorce decrees because all or nearly all policies would contain the express terms needed to meet the exception in Section 75-2-804 sub 2. Ms. Snyder had failed to rebut the presumption that her divorce from Edward Hertzske revoked his designation of her as primary beneficiary on the policy. Because of the lack of express terms necessary to claim an exception under 75-2-804-2 in either the decree of divorce or the policy, Ms. Snyder's designation as primary beneficiary of the policy was revoked upon divorce.